Kari Morrissey is still the special prosecutor on Hannah Gutierrez's case. The DA's office, before this order came out, and this order came out July 31st. Prior to this court order coming out, Kari Morrissey was still the special prosecutor on the Hannah Gutierrez case. And the DA's office had said, Kari Morrissey stays on this case. Will anything change after the court's scathing order in the Baldwin case? Maybe, maybe not. But for now, Kari Morrissey on the same day, July 31st, filed her response to the defense motion from Hannah Gutierrez for new trial. She got permission to go over page length, and so it is a very long, by the looks of it, motion. I have not gone over it yet, but when we saw the response to the request for immediate release, it was met with quite a lot of snark and throwing Baldwin under the bus. What we've covered already is Kari Morrissey's responses to the defense request for immediate dismissal of Hannah Gutierrez. Hey, Your Honor, you've got to let her out. She's in custody. She's in prison for 18 months. Let her out immediately. And the DA said, well, it's premature to ask for this. This is the wrong process. And how we have to address the motion for new trial before we ever get into whether or not Hannah gets released. Keep in mind that the arguments in Hannah's case are very different because Troy Teske went to Hannah's lawyer first. Hannah's lawyer saw the rounds that Troy Teske had. So Hannah's lawyer knew. Baldwin's lawyer didn't. And that's why these cases might go differently. But I think the court is going to hold the prosecution with a very, very tight leash on this and not give them the benefit of the doubt at all. I think Kari Morrissey has lost credibility in the eyes of the judge, and that is my opinion based on reading that last ruling. So Morrissey is not going to get a pass on anything, which means when this goes to oral argument on these motions, it is going to be spicy. Am I here for it? Yep. Undersigned counsel testified truthfully when asked why Ms. Johnson withdrew from the case during the motion hearing. Prior to the lunch break on July 12th, without hearing any of the testimony or argument related to defendant's Baldwin motion to dismiss, the court went off the record and notified undersigned counsel and Spiro that she was intending to dismiss the case. What? That's new information. This is why the court was like, Ms. Morrissey, you don't need to testify. The court tried to stop her. This is why the court was like, I already told you where this is going. That's why Baldwin and his wife were sitting there like petting each other in court. Because we knew Baldwin looked happy. His wife looked relieved. They were sitting in court like this with each other. And now we know why, because the court told Spiro, who told Baldwin, that the court is going to dismiss it. Undersigned counsel disagreed that self-preservation was an appropriate reason to dismiss a homicide case, but a Brady violation is. Disagreed that a dismissal was warranted under the circumstances and proceeded to a full hearing. That's accurate. Kari disagreed that a dismissal was warranted under the circumstances. That's true. Ms. Johnson did not want a public hearing out of concerns for self-preservation, and undersigned counsel testified truthfully in this regard. Undersigned counsel has not had a win at all costs attitude in the Rust case. In fact, it has been the opposite, and Mr. Bowles knows it. 42 pages of opposition filed by Kari Morrissey with quite a lot of snark, a very on-the-nose statement that she disagrees with the court's ruling in the Baldwin case and still doesn't understand how the court came to that ruling. CEG, the court's scathing written order in the Baldwin case. She talks about an undisclosed Seth Kinney interview, an undisclosed expert motion, and the ammo from Troy Teske. The ammo I don't think is super relevant to the motion for new trial. The defense had it. It was a defense witness. The defense chose not to call the witness. I don't think that comes up at all. The undisclosed Seth Kinney interview, I don't think is as easy as a question. And the undisclosed Hag report, I don't think changes things all that much. Yes, the state should have turned it over, but after trial, I don't think there is a remedy for that, because the first thing that has to be proven by the defense for the new trial motion to get granted is that it probably would change the result if there was a new trial. And I don't know if showing that somebody may have done something with the weapon changes Hannah's responsibility to do her job. That's possibly the same with the Seth Kinney interview, but without the entire interview, it's hard for me to really evaluate it. But you have to show that something in Seth Kinney's interview would change the result if Hannah gets a new trial. I think that's a very difficult standard for the defense here, because the strongest testimony to me in the entire Gutierrez prosecution were Hannah's own words in her multiple police interviews. It was her job to check the ammo. She wished she had checked more. She doesn't remember if she checked them all. She shook the box together. I don't think anything changes that testimony. And I understand that it's like, but it seems different for Baldwin. Baldwin's dismissal was a result of a Brady violation during trial, and there was no other remedy for the court. Defense for Hannah is asking for a new trial, but that comes under its own decision matrix, its own elements that include the result would have been different. Baldwin didn't have to show that this changes his trial. It was a sanction against the prosecution and police. Different than the motion for new trial. So we are dealing with different standards, with different elements under different case law in the Baldwin case and the remedy in that case versus does Hannah get a new trial? Hannah has a much more difficult argument to get a new trial than Baldwin's argument for a dismissal. Will the court do it anyway? We'll see. If the court decides that the appropriate sanction here for the prosecutor's behavior and that the result might be different because of intervening causes, we'll see. But it is a much more difficult argument for the defense to make. And I don't think the court's going to release Hannah while that decision is being made, no matter how upset the court is with Kari Morrissey. But I don't think Kari Morrissey telling the court that their decision in the Baldwin matter is flawed is going to go over well at all. No. But part of judicial temperament is being able to put that aside and look at the facts here and the law and see if the facts as they are and the law as it is warrant a new trial for Hannah Gutierrez, and they very well may not in this case. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.